Stop scrolling and listen to me for 20 seconds, because if you are in the United States on a visa right now, and you're thinking about flying out for a wedding, a family emergency, a quick vacation, even just for a week, there is one detail in your situation that can turn that trip into a locked door on your way back in. And most people don't realize it until they're standing in another country with a canceled return flight, an email from HR asking where they are, and a passport stuck in a US embassy for additional review with no clear timeline. So I'm going to say it directly to you. If you need a new visa stamp to re-enter the US, or you have a pending immigration application that changes your status, or you're traveling on any kind of parole-based travel document, March 2026 is not the moment to assume everything will go smoothly, because the policy environment right now is unforgiving. Processing is unpredictable, and the smallest issue can snowball into months outside the country. Here's what most people don't realize. Leaving the US is the easy part. Coming back is the test, and that test is controlled by two separate systems that don't care about your plane ticket or your job start date. First, the US Consulate abroad, which decides whether to issue your visa stamp, and then CBP at the airport, which decides whether to admit you at the port of entry. Even if you have the right document, admission is never guaranteed, because CBP officers determine admissibility upon arrival. And that's not a slogan, that's literally how the process is structured. Now let me answer the question your brain is screaming. What visa are you talking about? What is this visa? In this March 2026 update, the highest risk situation is not one single visa label, it's a profile. You are at high risk if your re-entry depends on getting a new visa stamp abroad or on discretionary parole, or if you have any pending change, extension, adjustment, asylum, TPS travel authorization that can be treated as abandoned or can trigger re-entry scrutiny. That includes a lot of real people. F1 students with an expired visa stamp who must renew abroad, students whose SEVIS record is shaky or who are on OPT and don't have their EAD in hand, H-1B workers who assume stamping will be quick but get hit with administrative processing, pending adjustment applicants who travel without advance parole, asylum applicants who leave without advance parole, TPS holders who leave without TPS travel authorization, anyone with a pending I-539 change, extension of status, and anyone who has even a small status violation in their history that you've mentally minimized because nothing happened last time. Source. And here's where things get dangerous, because people hear warnings like this and think it's fear-mongering, until they understand the chain reaction. If you leave the US and you need a visa stamp to come back, you are voluntarily putting your entire return in the hands of consular processing timelines, background checks, and administrative processing. And the Department of State is very clear that when a case needs administrative processing, the duration varies based on the individual circumstances of each case. They also explain that a 221G refusal means the officer couldn't conclude eligibility at that time, and you may be asked for documents or be placed into additional processing, and you can't argue your way out of that at the window. You wait. So March 2026 isn't about a single new law that says, don't travel. It's about the reality that re-entry risk is higher when processing is tighter, vetting is heavier, and backlogs are unpredictable. And when you are the one outside the US, you are the one absorbing all the damage. Missed rent payments, missed school enrollment, lost assistantships, terminated employment, childcare chaos, and the emotional gut punch of being separated from your spouse or your kids because your quick trip turned into, we don't know when you can return. Now I want you to visualize what actually happens step by step, because this is where your mindset changes from, it'll be fine, to, I need a plan. Step 1. You depart the US, and the moment you do, certain pending applications can be treated as abandoned or can become practically useless. USCIS warns that travel outside the US can have severe immigration-related consequences, and they specifically state that if you filed Form I-539 to change to a different non-immigrant status, USCIS generally considers it abandoned if you leave before a decision. And having advance parole does not prevent abandonment of the change of status application. They also warn that when you return, you are likely to be denied admission if your current status has expired. Source, Step 2. You land in your home country or a third country, and you apply for a visa stamp if your stamp is expired or you need a new one. You hand over your passport, and now your passport is not in your pocket. It's in their system. Step 3. The interview goes fine until it doesn't. Maybe the officer asks about your work duties, your employer, your field of study, your research, your prior status, or your travel history. Maybe nothing is wrong, but the officer still can't finalize it that day, and now you're handed a 221G sheet or told you're in administrative processing. And the official government guidance is blunt. The timeline varies, apply early, and wait times published online do not include administrative processing. Source. Step 4. While you wait, your U.S. life doesn't pause. Your landlord doesn't pause. Your employer doesn't pause. Your semester doesn't pause. Your health insurance doesn't pause. And this is where families get blindsided. You thought your risk was the flight. The real risk is the waiting room you didn't know you might be forced into. And even if you get the visa stamp, step 5 is CBP. Because CBP officers inspect everyone arriving and determine admissibility at the port of entry. And their discretion is real. They can send you to secondary inspection. They can question your intent. They can look for inconsistencies. They can decide whether you've maintained your status and whether you fit what you're claiming at that moment. Now let's break down who is most at risk and who is not, because clarity is what keeps you safe. If you are in the U.S. in a clean, stable, non-immigrant status, you have a valid, unexpired visa stamp. You have no pending change of status. You have no prior overstays, no arrests, no unauthorized work, and you are traveling for a short trip with strong documentation. Your travel may be relatively safer. Not risk-free, but safer. The people who should seriously consider not traveling right now are the ones whose return depends on a fragile chain. F1 students are a classic example because your re-entry relies on multiple moving parts that have to line up perfectly. The ICE SCVP travel guidance spells out that you generally need a travel-signed I-20, a valid passport, and a valid visa to re-enter, with limited exceptions like automatic visa revalidation for certain short trips. And they explicitly warn that if your visa is expired and your SCIS record is terminated, you should not travel until your record is active, because you may not be able to renew your visa or return to the United States. They also state there is no guarantee CBP will readmit you, and that secondary inspection is likely in certain situations. Source. So if you are an F1 and your visa stamp is expired, or your DSO hasn't signed your I-20 for travel, or your OPT is pending and you might miss an RFE, or you won't have the EAD physically with you, this is not a casual travel season. It's a season where one missing document becomes a denial, and one denial becomes a life detour. And if you're an H-1B or other work visa holder, I need you to stop assuming your case is simple because you've traveled before. March 2026 risk is that even normal, legitimate cases can get stuck in administrative processing. And when your passport is held, you can't just come back and fix it later, because you are literally locked outside until the consulate finishes. Source. Now here's the part nobody is talking about loudly enough. People with pending adjustment of status or pending asylum are walking around with a false sense of security because they heard the words advance parole and assumed it means guaranteed re-entry. It does not. USCIS is crystal clear that if you have a pending green card application and you leave without appropriate travel documentation like advance parole, you may not be allowed to re-enter, and you may be found to have abandoned the application. They also say plainly that having an advance parole document does not guarantee you will be allowed to re-enter, and a CBP officer makes the final decision at the airport or border. If you're an asylum applicant, this is even sharper. USCIS states that if you are an asylum applicant and you intend to travel and return, you must apply for and receive advance parole. And if you leave without it, they will assume you abandoned your asylum application, meaning your trip can destroy the very case that is protecting you. Source TPS holders, I'm speaking to you directly too. USCIS warns that if you have TPS and leave without first obtaining TPS travel authorization, you may lose TPS and may not be able to re-enter. And if you have a pending TPS application and leave without advance parole, USCIS may deny your TPS application and you may not be able to re-enter. Source. This is why in March 2026, the do not travel warning isn't about paranoia, it's about exposure. When you travel, you expose your case to the harshest parts of the system all at once. Consular processing abroad, airline document checks, CBP inspection, and the risk of being trapped outside while your US deadlines keep ticking. Now let me make this painfully real with scenarios that mirror what I'm hearing every week. Scenario 1. You're an F1 student, you've been in status, your visa stamp expired last year, and you tell yourself, I'll just renew it when I go home for 2 weeks. You book the flight, you go home, you apply, and you get told, administrative processing. Days turn into weeks, your lab needs you, your professor can't hold the position, your lease renewal hits. You start pleading with the consulate email inbox and getting template responses because the government itself says timelines vary. Scenario 2. You're on H-1B, you take a quick trip to attend a sibling's wedding, and at the visa interview, you're asked to explain your job duties in plain language. You say something that accidentally doesn't match the way your petition describes the role, and now you're asked for more documents. Your case is paused, and your employer has to decide whether they can keep your job open. Scenario 3. You have a pending I-485 adjustment application, and you leave without advance parole because someone told you, it's fine if it's a family emergency. And now you've abandoned the application in USCIS's eyes, which means you didn't just take a trip, you reset your future. Scenario 4. You have a pending I-539 extension or change of status, and you think, it's pending. That means I'm protected. But USCIS warns that leaving can lead them to treat it as abandoned, and then you try to return with a status that is no longer valid the way you think it is, and the airport becomes a cross-examination. And scenario 5, the one that breaks people emotionally. You have kids, you have a mortgage, you have a life here, and you travel for a funeral thinking you'll be back for Monday, and instead you're on FaceTime trying not to cry while your child asks, when are you coming home? And you have no answer, because your passport is still inside a process you can't control. That's why this March 2026 update matters. The risk isn't always denied forever. The risk is stuck long enough to lose everything you built. Now, who is not at high risk? If you are a US citizen, this video is not for you. If you are a green card holder, your travel risk is a different conversation. Still real if you have long absences, but you're not dependent on a visa stamp the same way. Today we're talking about visa and parole-based re-entry vulnerability. If you are a non-immigrant with a valid, unexpired visa stamp, stable status, no pending changes, no violations, and you can afford delays without losing your job or school, your risk is lower, and travel may be reasonable if you prepare carefully. But here's the part nobody is talking about. You don't get to decide whether your case is simple once you leave. The system decides how much it wants to look at you, and in tighter policy environments, more people get looked at. CBP can send you to secondary inspection without warning. And secondary inspection is where small issues become big problems because pressure, fatigue, and confusion make people answer inconsistently. And the consulate side is where perfectly legal cases can still stall in administrative processing because the government openly acknowledges that additional information from sources other than the applicant may be needed to establish eligibility, and the timing varies. So what should you do, practically, starting today? First, if you fall into any of these high-risk profiles, expired visa stamp that must be renewed abroad, pending I-485 without advance parole, pending asylum without advance parole, TPS without travel authorization, pending I-539 change extension, any overstay history, any arrest history, any unauthorized employment issue, do not gamble on travel without speaking to a licensed immigration attorney who can look at your exact facts, because general advice is how people get hurt. Second, if you must travel, you treat it like a mission, not a vacation. You carry proof of your status and your ongoing ties. You carry the correct travel document issued for your situation. You carry employment letters and recent pay statements if you're working, school verification and properly signed I-20 if you're an F1, your EAD if applicable, your USCIS receipt notices if you have pending cases, and you build a time buffer that assumes delay, not speed. Third, you plan for the consulate reality. You do not schedule travel that requires a visa stamp renewal if you cannot survive being stuck outside for weeks, because administrative processing is explicitly unpredictable. Source. Fourth, you protect your status before you move. USCIS warns that if you remain in the U.S. longer than authorized, you may be barred from returning and/or removed, and they advise checking your I-94 and filing extensions early, meaning timelines and compliance matter even before you ever step onto a plane. Source. And finally, you stop trusting "it worked for my friend" stories, because immigration outcomes are not viral trends, they are individual case files. And March 2026 is an environment where those files are being interpreted with less patience for missing pieces. If you take one thing from this, let it be this. Travel doesn't just test your passport, it tests your entire immigration story. And the price of being wrong is not embarrassment. It's separation, lost jobs, lost semesters, lost income, and a future that suddenly feels shaky because you stepped into a process you didn't fully understand. This video is for informational purposes only and does not constitute legal advice. Immigration situations are highly fact-specific, and policies can change, so you should consult a licensed immigration attorney about your specific case before making travel decisions.